There are some other issues to deal with when you consider an estate, and I have those under special consideration. Under what's now called the Family Law Act, you've heard of the notion, perhaps, of a matrimonial home. And since about 1980, in Newfoundland and in many other provinces of Canada, most of them, I believe, if you are married and you own a home in which you live even for one day with your spouse, husband or wife, even if that is in your name on paper, it becomes half or jointly the property of your spouse on the day you live in that home with that person. So that's an important thing to know, that the mere fact that it's in a person's name doesn't mean that they actually are the sole owner of it. So if, for instance, a husband owned a home, they brought into marriage, and then lives in it, however briefly, with the wife, then on his death, it automatically, the entire house goes to the wife, unless you've done something else, which is to opt out of the Family Law Act, which seldom is done. So the reality is that you need to understand that if you haven't opted out, and you've lived in that property jointly, even though it's not in both parties' names, then it will automatically go to the surviving spouse. And that means, by the way, it doesn't go through the will. So if I happen to die and my wife then will get it automatically, it does not go through my will to whomever I might want to give it to, whether it's a charity or some other individual or my children for that matter. There also is the question of joint bank accounts. And while there are circumstances in which you can will the contents of a joint bank account to an individual, again, it is pretty much the rule that if you put money in a bank account jointly with somebody else, then at the end of the life of one of the joint account holders, the balance in the account will then go to the surviving person on the account. And that's particularly important when you're considering how sometimes elderly people and people who are having health problems, one sort or the other, will have a joint account with a child for practical reasons, to pay bills and that kind of thing, but certainly the argument will likely be on the death of the older individual that in fact the balance of that account will go to whoever the child is. Again, there are other arguments can be made, but that's sort of the general rule we need to be concerned about. And anybody establishing a joint account needs to understand that risk. So even though it may have been for practical purposes, it may well be that a court will find that in fact it was intended to go to that child, to the exclusion of perhaps other children in the family. And that can cause all sorts of problems. I can tell you from my practice over time. And I guess to that extent, I would say that if somebody is establishing a joint account, the intention is not that the balance goes on death to the surviving person. It's wise to have some documentation about the intention prepared at that point in time, so that can be referred to if any dispute arises down the road. We'll also talk about what are called RRSPs and RRIFs. An RRSP, of course, is a registered retirement savings plan, and a RRIF is a registered retirement income fund. Both of them are two halves of the same coin, two sides of the same coin. The RRSP is a place that the government allows people to set up through a financial institution to put money in and save for retirement. It allows money in that account to accumulate tax-free, and by the time you were 71, I believe, 69 now, you actually have to start taking money out, and then it becomes a RRIF instead of an RRSP. It still enjoys the same tax protection, except you can't leave it all in. Every year you have to take out, I think, a minimum of 10% of the value of that. One of the things you can do, but don't have to do, if you have an RRSP or a RRIF, is to designate a beneficiary. And if you have designated a beneficiary, then the beneficiary will actually get the content of that account, the RRSP account or RRIF RRIF account, on death directly. It does not have to go through the will, through the estate of the individual. If you don't designate somebody, it will actually go directly to the estate and then have to go in for that purpose. So again, in the husband and wife situation, you'll often see one of the spouses will designate the other spouse as a beneficiary so they can get access to that money immediately on death, as opposed to having to let it go through the state, which can take, if there's a will or even if there isn't a will, take a number of months to go through the court process, and again, that money might not be easily accessible. So having a beneficiary on an RSP or RIP is a really good idea. I've already mentioned the matrimonial home issue, and I just make the point that that doesn't apply to a home you share with a common law partner. There's no such thing in Newfoundland as a common law marriage, and people will refer to it as that, but you actually have to be legally married to get the protection of the matrimonial home issue in the Family Law Act. So just to understand that is the case now. That's not to say that people who buy a home jointly, of course, don't have that same protection of what's called joint tenancy. So the surviving partner will get it, but you actually have to set that up legally at the time you buy the house to make sure that both parties' names are on the house as joint tenants, and often will be on the mortgage if the mortgage is joint tenants as well. So that's the thing to think of. Then there's the question of changing your will, and you can do that anytime. And it's something that you can do in the middle of the night if you choose. The fact you've made a will doesn't mean you can't either have a new will altogether or amend the will that you have. If you make a new will and you date it properly and you make sure that it's signed properly before witnesses, I have mentioned before, and that new will overtake the old will. In other words, the old will no longer be effective. And again, one of the things to be concerned about is making sure that somebody knows where your will is. So if you have a safety deposit box, it's usually wise to tell somebody you have a safety deposit box, and that's where you keep your valuable papers. Many law firms, if you in fact have it done by a lawyer, they'll have a vault, they put that in, so it's safeguarded in that way, or you may have a special place to put documents. But it's important not only that it be safely put, but somebody know where it is, because after the person's gone, of course, you can't find it. The reality is the fact that you made a will doesn't count. It's the actual physical document that you have to be able to put your hands on when the court is dealing with what will, if there is a will be probated by the court, and therefore in what way your property will be distributed. Instead of actually having a whole new will, you can do what's called a codicil to a will, which you've probably heard about on television from time to time, and that's just an amendment to the will that has to be done in the same way as the will. So you have to have the witnesses present that should refer to the will and say, by virtue of this codicil, I am changing my will to say this instead of what I said previously. And again, that's something that a lawyer can help you out with. Commonly, people do not do codicils, in my experience, particularly in relatively single states, because it's easier just to do a whole new will and avoid any confusion. Marriage is another issue you have to be concerned about. If you get married, then your original will is canceled on your marriage. So it's wise to do a new will immediately upon your marriage, unless you do what's called to make a will in contemplation of marriage, and you have to say that right in the document to allow it to survive the marriage. So again, it's something that you need to be concerned about at the point you are determining if you're going to make a will. On the flip side, if you get divorced or separated, your will still counts. And some people get caught out by this because they forget to change their will when they've separated or even get divorced, and suddenly their ex-spouse, on the death of that individual, is getting all of the assets or some part of the assets, which was never intended, particularly in controversial situations. And I've seen that happen a number of times over time. Again, very upsetting to family members, but there's very little you can do about it. So once you make a will, you have to be concerned about updating your status, having a new will when the time comes, and making sure that as your wishes change, you record that or reflect that in a new will. And I guess that will come back to for somebody who perhaps is worsening in their disease process, that there may come a point in time when they can't change it either, and that comes back to capacity, because you're stuck with what you have in place if there comes a point in time when you no longer have capacity to be able to make a will or determine what your decisions are going to be from a legal or financial point of view. And that's why it's important for people who are caregivers and family members to assist a person who is suffering from Alzheimer's or related disease to ensure that they make these decisions at a time when they're still able to make the decisions. And that may again involve making sure we have a doctor or a lawyer, they're both involved, to ensure the person can make that change at an appropriate time. Because once they have gone beyond that point of capacity, which is the kind of test I mentioned a few moments ago, then there's no going back and there's no changing. They're stuck with whatever the will says at that point in time. So it's an ongoing assessment process, and many, certainly in my practice, we see that frequently, having to have people in and determine whether we think they can now change what they had or have a new will or some other new document signed without perhaps having a court order or something like that. And it's much easier if the person has settled their intentions for a will or otherwise at that point in time.
Fred, I was just wondering, if you put enduring power of attorney or different things like this in place for property and personal care, would that person be able to step in and do any alteration to the will because you have already declared them
Not to the will.
person responsible for those things?
Not to the will. They only can act pursuant to the terms of the power of attorney or the Advanced Health Care Directive, both of which we're going to talk about in a moment, during the life of that individual. So whatever the individual dies with, that's what it is. Now, that's not to say that the person, as I'll discuss in a moment, with power of attorney, can't do things during the lifetime of that person to give away or otherwise direct how assets are going to be dealt with. But at the point of death, that person who has power of attorney does not have the right to do anything to change the will. The will exists as it is.
As it is. Okay, thank you for answering
that. No problem. I've mentioned as well the death of the beneficiary, and that's important because when somebody decides who the beneficiaries are going to be, often might be their children, and if one of the children dies, then in that circumstance that person no longer has the right to take if they die before the person who made the will dies. There is an exception that if you have a will and the person is perhaps has a child who perhaps isn't born yet, but is what they call un ventre sa mère, which means that the child is in being in the womb, then that child, even though not born at the time of the beneficiary being named, will be able to take the share of that the individual who has, the beneficiary who has died. So again, it doesn't happen all the time, but it is an important consideration, again, from the family fairness point of view, because you get these situations where, you know, suddenly you've got a child of a child who feels that they might not be being properly treated under this. So you have to understand that if the person is actually in being at the time of in the womb, at the time of the death of the individual, then that person will take the share of the beneficiary who dies. So again, getting to complicated legal things, but just saying these are things you should be aware of and as you're planning your will.